is going to discuss very important aspects relating to the international law mechanisms relating to the use of force and the current Russian and Ukraine crisis. So in this backdrop, when I have requested Professor Saul to deliver a lecture, and he gladly agreed and readily accepted, and we are really thankful to you, Professor Saul, for this gesture of coming and interacting with our students. Sir, we have started this law school in 2020. There's a VIT AP School of Law, and we have 2 batch of students, and we are gearing up for the admissions to the 3rd batch. And also this university, it's been there since last 35 years, imparting education in engineering, management, sciences, and humanities. And we have 4 different campuses in India. And this particular campus is situated in Andhra Pradesh, which is a southern part of India. And we have almost some 45,000 students in this university campus, and spread across, we get students from all over India, and also we have students from the abroad, various different countries, they are joining with us. And with this modest beginning, we started law school in 2020 during the pandemic. And this particular time, we could able to get a really good number of students, and they are very enthusiastic. We also have PhD programs in law, and we are offering, we have 8 full-time scholars working on this particular PhD currently. And with that, I will introduce you to our students. My dear students, we have with us Professor Saul from Sydney Law School, and he's one of the finest professors of international law and also practitioner. And Professor Saul is currently Charles Chair of International Law at the University of Sydney, and also Associate Fellow of Chatham House. This is a part of the Royal Institute of International Affairs in London, which is a very prestigious institute. He was also Fellow of Whitlam and Fraser Visiting Professor of Australian Studies at Harvard University in 2019. He has published more than 20 books, and currently is also working on his book on counterterrorism, and one of the finest writings which he has, and it's guiding lots of students, practitioners, judges across the world. And over about 100 refereed articles he have written, and also he has got scholarly presentations and awarded millions of dollars as a research grant from various funding bodies. He is a very, very active researcher and a dynamic teacher. And he appears before international tribunals, national tribunals, and the courts to represent various aspects of international law. And he has a very thought-provoking book on defining terrorism in international law, which I think a lot of subscribers and most of the students study. And it is, in fact, one of the prescribed book on international students. And he also has a commentary on the International Covenant on Economic, Social, and Cultural Rights, which was published in 2014. And he was also awarded a prestigious merit certificate by the American Society of International Law. And his latest book, the Oxford Handbook on International Law in Asia and Pacific, it just came up, and it's a really good contribution for the subject of international law. And Professor Saul has been teaching at Sydney, and also he is visiting at Oxford, Harvard, and the Hague Academy of International Law, and also he is visiting in China, India, Nepal, Cambodia, and Italy. He is also visiting professor at the Max Planck Institute of International Law and the Raoul Wallenberg Institute of Human Rights. And also he has given the lectures at the Cambridge University, New York University, London School of Economics, and also he contributed to the UN Audiovisual Library of International Law. So if we keep on undertaking his contribution to the development of international law, it's a very immense. As I said, he's one of the active researcher of international law, one of the finest scholars of an international law. And I always read his books and his contributions very passionately because it gives a very lucid explanations of various aspects. With this brief and humble remarks and also introduction, I would now welcome Professor Saul warmly to the VIT AP University and VIT AP School of Law to deliver the lecture. And it's a very privilege to us, sir. Thank you so much, sir, for your presence and agreeing to deliver lecture. Thank you so much. Now it's yours, sir. Thank you. Professor Saul, I think we are not able to hear your audio. There is some. Yeah, now it's fine, I think. Professor Saul, we are not able to hear you. There is some. Can you hear me, Professor Saul? Yeah, but yeah, I can't hear you. Yeah, guys, can someone just unmute your videos and can tell us whether you are able to hear or not?
No, no audio, sir.
No audio, yeah.
No, sir.
No audio, sir.
Thank you. Yeah. Pandya, you have to mute your audio. It's a little disturbance from your side. Thank you. I think you'll be joining in maybe in a minute's time. He has some issues with regard to audio is concerned. Dr. Francis, good morning.
Good morning, sir.
Sorry for this. I think Professor Saul, yeah, is there.
Now, Professor Chaka, can you hear me this time?
Yes, sir. Thank you very much. We could hear you. Thank you.
Fantastic. Okay. Look, I'm sorry. I'm not sure what happened there. But thanks so much for inviting me, and I'm delighted to be with you. And I remember we met many years ago in Delhi when you were then the regional legal advisor.
You are right, sir. ICRC. You're right. Thank you.
And of course, the ICRC, the Red Cross, is playing a hugely important role in the current conflict in Ukraine involving Russia. Now, you've asked me to give a talk about the international law on the use of force issues which apply to that conflict. So I'll focus on those issues, but I'm also happy in questions, if students are interested, to talk also about the international humanitarian law issues which apply, because as you may know, on the one hand, the law on the use of force regulates the initial resort to military force between states, whereas international humanitarian law then deals with the regulation of the conduct of those hostilities once the war gets underway. And so when we talk about war crimes or violations of the law of war, which you will see in the media, particularly by Russia. That's international humanitarian law and also international criminal law, because of course, war crimes liability of individuals is an important part of that law as well. So I'm happy to talk about that in questions if people are interested. Now, on the law on the use of force, the starting point, of course, is that really since 1928, the use of military force in international relations to settle disputes between countries has been illegal. So for the first time ever, a treaty called the Kellogg-Briand Pact, which most countries, then independent in the world, signed up to, prohibited resort or recourse to force between countries. That was then strengthened in 1945 in the United Nations Charter, where these days Article 2, Paragraph 4 of the UN Charter prohibits the use of force in international relations between states. And really, there are only two legal exceptions to that very comprehensive rule. One is self-defense. So if, according to Article 51 of the UN Charter, a state is the victim of an armed attack, then it has a right to use military force in self-defense solely for the purpose of halting and repelling that attack. And if it's force used in self-defense, that will not be regarded as an illegal use of force under Article 2.4, because self-defense is an excuse or a justification for that use of force. The other exception is what we call collective security enforcement action taken by the United Nations Security Council under its special powers to maintain or restore international peace and security under what we call Chapter 7 of the United Nations Charter. And those measures can include non-military ones like sanctions, or another good example from the 1990s was the establishment of international criminal tribunals for the former Yugoslavia and Rwanda. But also Chapter 7 allows the Security Council to essentially authorize countries to use military force on its behalf to restore international peace and security. And that, again, will not be treated as a breach of the prohibition on use of force in Article 2, Paragraph 4. Now, there are some more controversial claims about when it might be lawful to use force, military force, in international relations. But I'll touch on those when I address now what Russia has claimed in relation to its military action, what it calls a special military operation in Ukraine, which commenced just over a month ago now. Really, of course, Russia's use of force against Ukraine began back in 2014, the year 2014, when, of course, Russia launched its invasion of firstly Crimea, and then the eastern area of Ukraine known as the Donbass region, which comprises two semi-autonomous areas under Ukraine's governance system. So what has Russia claimed? Well, I think the first point to note is that although Russia has made many legal claims seeking to justify what it is doing in Ukraine, none of those claims stands up to scrutiny under international law. Russia's action in Ukraine is what we call aggression, which is illegal under customary international law. It's also a prohibited use of force under Article 2.4, because any use of military force between states comes within that provision. So the question then is what Russia is doing justified in self-defense, or is it justified by some other legal basis which the international community would accept? So firstly, Russia has claimed to be acting in what we call individual self-defense against what it says is an armed attack by Ukraine upon Russia. Now, it's a little hard to understand precisely how this claim is being made because Russia has said a variety of different things, but it roughly goes like this. It says the West has been arming Ukraine. So this is prior to the latest invasion. The West has been providing weapons to Ukraine. The West has been seeking to enable Ukraine to join NATO, a military alliance, which Russia says is directed against Russia. President Putin has said Ukraine is seeking supposedly to acquire nuclear weapons, which would be, again, directed against Russia. And also that there is a Nazi or fascist threat in Ukraine, again, threatening Russia. So if you think about those claims, none of those things is evidence of an actual military armed attack on Russia. Ukraine has not used, prior to this recent attack by Russia, Ukraine has not used any military force on Russian territory or against the Russian military. And so we can rule out self-defense on the basis of Ukraine having launched an armed attack. That's not the end of the story, though, because there is also probably increasing acceptance in international law these days that self-defense is or may be available not only where there is an actual use of military force, but where a military attack is imminent. In other words, about to occur in the very foreseeable future. It's a credible threat. You've got good intelligence that that threat will be carried out. And if not immediately, it's going to occur at least fairly soon. Now, I say international law may accept self-defense against imminent armed attacks because the question is not well settled under international law. And indeed, before the terrorist attacks of September 11 in 2001, probably most countries did not accept that there was a right of self-defense against an imminent attack. Article 51 of the UN Charter says there's a right of self-defense if an armed attack occurs, not if an armed attack is about to occur, or in other words, is imminent. Nonetheless, post 9/11, more countries seemingly have supported what we might call anticipatory self-defense against an imminent attack, to the point that even some years ago, the United Nations Secretary General seemed to accept that there is a right of anticipatory self-defense against an imminent armed attack. That still is, I would say, controversial because there is no clear international case law, for example, from the International Court of Justice, accepting that. There are large groups of states, like the non-aligned movement, which comprises about 120 countries, a clear majority of the international community, has not endorsed anticipatory self-defense against an imminent attack. On the other hand, some states, particularly some powerful Western states, plus Israel, Russia, have argued for such an expanded right of self-defense. Even if there is a right of anticipatory self-defense, again, here on the facts, there is no evidence of any imminent attack to be launched by Ukraine upon Russia. There's just zero evidence for that. Russia has not presented any evidence like that. Independent sources have not suggested that any such attack is there. And of course, it's, on a common sense approach, utterly implausible. Why would a much smaller country like Ukraine launch a first strike upon a nuclear-armed superpower like Russia? It just defies plausibility, particularly given that Ukraine also is a democracy. It has no record of military expansion into neighboring countries' territory. So what this means then really is that Russia's self-defense claim is an even broader version of self-defense, which we sometimes call preemptive or preventive self-defense. In other words, there's no armed attack. No armed attack is imminent, but Russia nonetheless perceives there to be some speculative, far off, more distant threat posed by Ukraine, which, some way in the future, maybe 5, 10, 20 years' time, if, Ukraine manages to get a nuclear weapon in that time, if the government turns into a bunch of fascists or Nazis, and then they decide they want to start shooting at Russia, Russia saying that's a threat we need to counter now. So this is a version of what US President George Bush claimed in 2002 in his national security strategy after the events of 9/11, when he said, look, you've got to stretch the traditional concept of imminence beyond attacks which are about to occur to include defensive action against these more distant threats, because they're so serious, you just can't wait. Now, look, when President Bush made that claim, the whole world rejected it. Not only the United Nations, but there was really no other state on earth which endorsed that approach. When that kind of action has been taken, on the very rare occasion where it has occurred previously, it's been roundly condemned by the international community. An example is in 1981, Israel attacked and destroyed a civilian nuclear power plant under construction in Iraq. So this wasn't a military nuclear bomb facility. So Israel's logic went something like this. Iraq is building a civilian nuclear power station. It could be used to divert civilian nuclear material to a military weapons program that could succeed at some point in the future in constructing a bomb. That bomb would then be directed against Israel, and the government of Iraq would give the order to shoot that at Israel. Now, that's such a long chain of speculative hypotheticals that the world has simply rejected it as a lawful reason to use force. The United Nations Secretary General put it well when he responded to President Bush's claims of that kind back in 2004, when he said, look, if threats like that are so far off and speculative, then by definition, there are non-military means available for addressing those threats. That could be through the Security Council, it could be through diplomacy, it could be through multilateral fora, it could be through unilateral sanctions, weapons inspectors. There are all kinds of tools we have available as the international community, short of using military force, for dealing with threats of that kind. So Russia's claim that it is exercising self-defense to protect Russia is bogus and has no legal merit whatsoever. Russia's second legal claim, though, is that is a claim of what we call collective self-defense. So under international law, there's a right of self-defense if your own state is attacked, but other states also have a right to use force to defend another country that has been attacked if that other country requests foreign assistance. So a good example is the first Gulf War in 1991, when Iraq aggressively invaded Kuwait. Kuwait requested other countries to help it. A large coalition of countries went to Kuwait's aid and succeeded in expelling Iraq from Kuwait in that war. That was also an example where the Security Council, by the way, also authorized the use of force to expel Iraq from Kuwait. So there were two good legal reasons for using military force, which meant you weren't violating the Article 2.4 prohibition, which Iraq was violating. Now, in this case, what Russia is claiming goes like this. It says this eastern region of Ukraine, which has comprised the separatist regions of Donetsk and Lugansk since 2014, Russia recently recognized those areas as what Russia calls essentially two independent republics. In other words, Russia is claiming that those territories are no longer part of the sovereign state of Ukraine, but instead now form two independent countries. It then says that Ukraine's military is using force against those areas to try to recover them for Ukraine. And then that therefore constitutes an actual armed attack on those two countries. And at the request of those countries, Russia is providing military support in their collective self-defense. So it says this is justified by Article 51 of the United Nations Charter. Now, the problem with that, of course, is a very basic one. The right of self-defense is only something enjoyed by states. It's not something enjoyed by groups of people or separatists or even national liberation movements entitled to self-determination and to eventually become a state. But because they're not yet a state, they don't have a right of self-defense. And the critical problem for Russia is that those supposed independent republics are not states under international law. Under international law, to be a state, you have to have a defined territory, which these areas arguably do, a defined population, again, which they do, but an effective government, which they seemingly may have. But the critical problem from an international law standpoint is that these republics really do not have effective independence as entities in international relations because they are essentially dependent on Russia. And Russia has such a large degree of control over their very capacity to govern those areas. Russia had troops on the ground even prior to this operation. Russia supplied them with weapons and finance and really propped them up so that they could fight this war. Really, international law would not recognize these entities as having sufficient sovereign independence to be recognized as states. For the same reason, they don't have a capacity really to enter into international relations like treaty relations, diplomatic relations, trade relations, etc., because they are not treated as separate sovereigns from Ukraine. What that means, of course, is that these are just really separatists or rebels or insurgents rebelling against the sovereign authority of the Ukraine state. Ukraine, as any sovereign state has a right to use force on its own territory to restore law and order, to suppress uprisings, suppress rebellions, and to restore control, its governmental control over its own territory. And any Russian intervention on the side of the rebels is itself, quite apart from being an unlawful use of force, is an unlawful intervention in Ukraine's sovereignty as well. There's no right under international law to intervene in a civil war to help the rebels. In contrast, there is a right to provide support to a government to restore control over its own territory as against rebels and insurgents. So a related argument, a third argument then, which is connected with what I've just said, is that Russia has also made a claim that this is some sort of case of self-determination, a right of self-determination of these predominantly ethnic and linguistic Russian minorities who dominate the eastern areas of Ukraine. And the argument goes like this. Russian peoples in this area of Ukraine, Crimea plus the eastern areas, have been so oppressed by the Ukraine state that somehow this is a denial of self-determination, which gives these people a right to become independent and to separate from the state of Ukraine. Now, there are really two difficulties with this argument. One is just a factual one, which is that there just is no evidence of the kind of grave, systematic oppression, violation of rights of Russian, ethnic Russians or Russian speakers in eastern Ukraine, which would attract some kind of self-determination right like that. Certainly there have been debates and some laws in Ukraine and controversy over the extent to which the Russian language should or should not be recognized within the Ukrainian legal system. But that is nowhere near the threshold of gravity which is ordinarily talked about in debates about self-determination for groups of peoples within an existing independent state. This is categorically different, for example, from the situation in Kosovo in 1999, where there was widespread violent ethnic cleansing by the Yugoslav government against Kosovar Albanian Muslims as a distinct people within the territory of Yugoslavia. So there's really no factual basis for the Russian claim. The second problem is just a legal one, which is that this kind of self-determination claim is very controversial still in international law. So when we talk about the right of self-determination, what is well established under international law is that it is the right of a colonial people to freely exercise or choose their political future, including by becoming an independent state and throwing off the shackles of colonial rule. I mean, this is precisely what the process India went through at the end of the British era. That's well accepted. That's the basis on which a large number of states was created after the Second World War, as colonialism was brought to an end between the 1950s and, for the most part, the mid-1980s. What is controversial, though, is extending the right of self-determination to groups of people within countries which have already achieved independence from colonialism. That is not universally accepted as part of international law. Probably what you can say is that there is increasing support for some kind of limited right more limited right of self-determination for minority groups of certain kinds within existing independent states. But that right does not necessarily carry with it a right to secede, that is, to break away from the independent country of which you're a part and to form your own separate state. In other words, this kind of group or minority self-determination within a country means you might be entitled to autonomy within an area of the state. You might be entitled to your own political institutions and a large degree of self-rule. You could be entitled to linguistic and cultural rights and control over things like the education curriculum and so forth. But it doesn't mean you can also declare independence and become an independent country. Now, there's emerging support for that. Where it gets really controversial is whether there's what we call a further right of remedial self-determination in those cases where a group, a recognized, distinctive, cultural, ethnic, linguistic group within a country is so oppressed and is so victim to atrocities by their own government that at some point you reach a threshold where you do gain a right to secede and become an existing independent state. So this is a version of what some have argued in relation to Kosovo, because the Yugoslav state was engaging in ethnic cleansing. It was really past the point where you could expect Kosovar Albanians simply to keep living happily under Yugoslav rule, even if they had some kind of autonomy, because that was meaningless in practice. They were being so oppressed by the central state that the only way they could feasibly live is by becoming independent. Now, that issue was not addressed by the International Court of Justice in the Kosovo advisory opinion for the reason that the question asked of the court by the UN General Assembly, which requested the opinion, concerned the more limited question of what was the legality of a unilateral declaration of independence. And what the court said on that is that if the Kosovars declare independence, that's neither authorized nor prohibited by international law. And any consequences that flow from that will be addressed by other parts of international law. So, for example, we mentioned earlier the law on statehood. If the Kosovars do declare independence and they manage to effectively and independently govern that territory to the exclusion of the Yugoslav state, then good luck to them. You know, at some point they might become a state. But the court said nothing about an entitlement to become a state based on remedial self-determination arising from Yugoslav atrocities, oppression, etc. That the question was left unanswered. Another case you could mention is the Canadian Supreme Court's Quebec case, which is one where the French-speaking minority, a very large minority in Canada, living in provinces controlled by Quebecois French-speaking people, largely, were interested in potentially seceding from Canada and becoming their own independent state. And that is a case where the Canadian Supreme Court did say there could be a right of remedial self-determination in some circumstances. But on these facts, French-speaking Canadians are just not so oppressed, so denied internal political autonomy or cultural rights and so forth. They're just not so oppressed by the Canadian federal government that they would have any factual entitlement to remedial self-determination of that kind. And therefore, the question of the future status of the province of Quebec is one to be decided by all Canadians who are the whole people entitled to exercise Canadian self-determination as a whole. So this is on shaky ground legally, and it's absolutely an implausible claim factually, because there just is not any severe oppression of the kind Russia claims. Okay, a fourth argument I'd mention is one which is subject to current International Court of Justice proceedings. Russia has claimed it's preventing genocide in Ukraine against ethnic Russians. So there are different versions of this argument. So it's using military force to prevent genocide. It's a kind of humanitarian intervention using military force, like NATO did in Kosovo in 1999, to defend people's lives from grave threats. And another version of this argument is that it's the protection of Russian nationals at lethal risk in Ukraine. And these are, I'd add, arguments Russia also tried to make to justify its military intervention in separatist areas of Georgia back in 2008. What can we say about those arguments? Well, firstly, from what we've just said about the whole discussion of remedial self-determination, on the facts, there just is no evidence that Ukraine is perpetrating genocide or lethally targeting Russian ethnic Russians in Ukraine. So even if there were military rights to intervene in a foreign country for those reasons, the factual basis is just not here in Ukraine. Secondly, though, legally, like with the self-determination argument, all of those supposed reasons for using force are just not established or accepted reasons under international law. So it's widely accepted that even in a really morally justifiable case, perhaps like the NATO intervention to stop ethnic cleansing in Kosovo in 1999, it's widely regarded that intervention was illegal because it was not in self-defense. No NATO country had been attacked by Yugoslavia, and it was not authorized by the Security Council because Russia, among others, was essentially threatening to veto any collective action by the Council. So NATO decided to unilaterally intervene without legal authority for essentially moral reasons, to avert the humanitarian catastrophe. You may or may not agree with that morally and politically, but legally speaking, it's very difficult to argue that there is, widespread international practice in support of a right of humanitarian intervention. And the same is true of the use of force to protect nationals at risk abroad or to prevent genocide, which is a species of humanitarian intervention, but also, I guess, has a different aspect because under the Genocide Convention of 1948, all states have a duty to prevent genocide. So part of the Russian argument here could potentially be the duty to prevent genocide includes by using military force where necessary. Now, the Genocide Convention does not say that. The Genocide Convention, of course, is subject to other relevant rules of international law, which, of course, include the prohibition on the use of force, except for in self-defense or if the Security Council authorizes it. So the International Court of Justice has issued what we call provisional measures, ordering Russia to cease its military operation until the merits of the case are heard. And what Ukraine is arguing there is that Russia's intervention is an abuse of the provision in the Genocide Convention, which requires states to prevent genocide. Because, quite apart from there being no genocide, Ukraine argues that that provision does not authorize the use of force to prevent genocide. So these are really inflammatory justifications being used by Russia, but they have no plausible legal basis. You may well discuss humanitarian intervention in your international law studies. Of course, India's actions in Bangladesh, East Pakistan, as it was then called in 1971, are sometimes seen as a possible example of practice of humanitarian intervention. And it certainly did. India's intervention absolutely did help to prevent the atrocities being perpetrated by the then Pakistan government, which was based in West Pakistan, in suppressing the Bengali independence movement there. But India itself largely justified that intervention as self-defense because of the spillover military threats to India across the border. But there's a debate about that, which you may well know. Okay, finally then, I just mentioned one other claim being made by Russia, which resonates in our part of the world as well, because it's in a way something that China has been doing in the South China Sea. And Russia has also argued in President Putin's speech recently that Ukraine has historically always been a core part of Russia. In other words, it was, when the Soviet Union was dissolved in 1991, Russia was betrayed by the leaders of the Soviet Union who allowed Ukraine to become independent. The Soviet leaders also, according to Putin's narrative, wrongly gave Crimea to Ukraine in 1954, and it was always Russian, and Russia was just taking it back in 2014. Although Ukraine had periods of brief independence, so at the end of the First World War for a few years before being absorbed by the Soviet Union, really stretching back centuries, there's no difference between Russia and Ukraine. Ukraine is Russia. Now, I don't take a position on any of that historical narrative, because you really don't need to from an international law standpoint, because international law says regardless of whatever historical grievances you might have about existing territorial boundaries between states, those boundaries must always be respected. In other words, the stability of existing borders is deemed as an incredibly high value in the international legal system, because otherwise, if you allow every historical grievance to justify a use of force to change borders, you'd very, very quickly see an escalation of violence in many places around the world. Because even though borders were often drawn unfairly or arbitrarily by colonial map drawers, think of many of the borders in Africa, which just cut ethnic groups in half and placed them arbitrarily on different sides of borders. All of that is of course, terribly unfair. All of that can sometimes itself be a cause of violence if not addressed. But the solution to that, international law says, is not to allow force to decide those disputes. Instead, negotiation, peaceful settlement of disputes, territorial adjustments, all of those peaceful methods should be the ways by which those borders are changed or withdrawn or redrawn. So for that reason, even if Russia's claims are right and factually they're not, then it would not be a lawful reason for Russia to use force. This question came up in India. Of course, you may know about the controversial case of Goa, Portuguese Goa in 1961, which India essentially did militarily take back from the Portuguese. I mean, technically, that probably was a violation of Article 2.4 and the prohibition on the use of force in international relations to settle that dispute with Portugal. On the other hand, there was a lot of sympathy for that at the time because it was such an acute colonial situation in that context of the decolonization period. So like Kosovo, a lot of moral sympathy for it, even if technically legal problems with doing that. Okay, so that's Russia's claim in a nutshell. Professor Chaka, how much time do I have?
Yeah, you may take in a few more minutes, like 10 more minutes, then we can come back to question and answers. Thank you, Professor.
Perfect. So what I'll do in the remaining time then is really deal with how has international law responded to what is an unlawful armed attack and an aggression against Ukraine by Russia. First point, I think there has clearly been a very high level of solidarity internationally and sympathy for Ukraine, and a great deal of support using the available legal tools by other countries for Ukraine. Now, some things were not possible. So, of course, to start with the UN Security Council, Russia has a veto power there. So the Security Council could not do anything to stop Russia's aggression. Of course, that's a major limitation of the Security Council. The permanent 5 members all enjoy a veto. They don't have to give reasons for exercising the veto. It's a complete discretion. They don't have to recuse themselves from debate on a resolution or vote on a resolution if they themselves are the target of the resolution. So it is an extraordinary power permanent members have to shield themselves from the will of the whole rest of the international community. Put that in context, though, I'd say, and of course, it does highlight, of course, in an ideal world, the need for Security Council reform. On the other hand, of course, there are really practical power politics at play here. Even if the Security Council is reformed in the future, for example, to make it more representative, to put, India or Japan or South Africa or Brazil onto the council, I think it's almost certain that those countries themselves would not get a veto power. But more importantly, reform of the council, the current permanent 5 would almost certainly never agree to give up their own veto power. I just think in the world we've lived in for the last 75 years, since 1945, it's just politically inconceivable that those countries would agree to give up the advantage they enjoy. Now, when I say put this in context, look, of course, this is a major problem in cases like this. On the other hand, it was the price in 1945 of getting the great powers to agree to A, give the Security Council any binding powers at all, because its predecessor, the League of Nations Council, had no binding security powers. So it was much more toothless than the Security Council because it could only make recommendations. Giving them the veto was also the price of them participating in the United Nations and being part of the Security Council, and therefore having the power amongst those states who won the war to do things to restore peace and security. The resources you need to stop one country invading another, you need the great military powers on your side to do that. Australia is not powerful enough to stop other countries invading other countries. You need the United States. You need, in an ideal world, if their politics were different, countries like China and Russia. You need powerful militaries like the UK. And of course, you need, these days, a more representative balance of world power, including India, Japan, others. But this is still an incremental improvement on what came before the United Nations, as hard as it is to see that when a case like this demonstrates the futility of the Council in particular cases. Russia also can't be removed from the Security Council. There have been some arguments about that, but really to do that, you need the Security Council itself to make a recommendation to the General Assembly. And of course, Russia could veto that as well. So secondly, then, that's why we saw a pivot to the General Assembly, which did, in a resolution in recent weeks, gain a large majority of votes in the world. I think 141 countries out of 193 condemned the Russian invasion as aggression. So that's a pretty broad condemnation and sends important signals about the unacceptability of Russian behaviour, helps to mobilise political support amongst countries to give support directly to Ukraine or to impose sanctions, for example, on Russia. So that is a positive step. On the other hand, what I would say about that is, if you think about that, 141 countries, that still means about a quarter of the world, like 50 countries, did not vote to condemn Russia. Now, from what I said before, the prohibition on the use of force is perhaps the most fundamental, or at least one of the most fundamental rules of the post-war international order. Russia's invasion of Ukraine is the most clear and flagrant breach of that rule imaginable. And yet, a quarter of the world is not willing to condemn it as such. So I think that is, in some ways, a worrying sign. If you've got a quarter of the world not supporting the most basic rule in the international legal order, it's not just the usual suspects, authoritarian regimes who you'd expect not to vote for a rule like that. I mean, of course, North Korea was against it. Countries which either abstained or were absent from the vote, which again is not voting for it, included some really powerful, important democracies. India, a good example, Bangladesh, Pakistan, South Africa. I mean, these are very significant powers, potential contenders, some of them for seats on the Security Council if it were to be reformed, and yet they're not condemning aggression. Now, there are political reasons for that, which are sometimes, I think, disappointing. I mean, if it's because you buy Russian weapons, you're not willing to condemn Russia, I think that's a terrible reason. On the other hand, some states, and I know India has mentioned this, have said, look, we want a negotiated resolution. We want a peaceful resolution through diplomacy and so on. of course, that's a legitimate method for resolving disputes. But you can still do that whilst condemning flagrant aggression against another country. I mean, if you just say this is about a political negotiation, and Ukraine has to accept whatever political deal Russia is willing to give it, and you don't say that there are bright red legal lines in the sand which say this is always wrong and illegal, I think that does send a pretty worrying message about the consequences of using force. You won't be condemned, and you'll get to negotiate how you resolve the dispute that you yourself have unlawfully created. So I don't think that's necessarily a positive response. Thirdly, because the Security Council could not impose sanctions as it has power to do under Chapter 7 of the Charter, instead, we've had a broad coalition of states imposing sanctions on Russia, various financial sanctions, to a lesser extent, commodities sanctions, travel sanctions, targeting Russian state entities, like the central bank or state enterprises, targeting members of the Russian parliament, targeting Russian businesses and oligarchs, cutting them off from the international banking system. I mean, these are steps designed to inflict economic pain on Russia in order to hopefully change its behaviour. Now, of course, a limitation of what we call unilateral sanctions, that is, sanctions imposed just by whichever states that want to do that, is that they are inevitably less effective than United Nations Security Council imposed sanctions. Because Security Council imposed sanctions are universal. Every country must implement them under international law. Now, because the Council can't do that, we've primarily seen sanctions being led by the Western states and some others. That's still pretty effective because Western economies are so powerful and Russia is so integrated into the Western economies that it hurts them when the West imposes those. But of course, the limit is that there are safety valves all over the place for the Russian economy, dealing with China, dealing with India, dealing with other big economies which aren't imposing sanctions or not imposing them to the same extent of severity. The problem then is that it really blunts or dilutes the effectiveness of sanctions. Of course, at the same time, the West is limiting the effectiveness of sanctions itself out of self-interest. So, Europe relies on Russian oil and gas. The West relies on critical mineral commodities from Russia. And we haven't seen sanctions on many of those things because the West doesn't want to suffer too much economic pain in order to defend Ukraine. Sanctions are, by the way, of course, lawful because they are in response to Russia's illegal measures. And sanctions are a lawful, what we call countermeasure, in order to bring a state acting illegally back into compliance with its international obligations not to use force against Ukraine. In addition to state-led sanctions, we've also seen a kind of global civil society movement. So private businesses, multinational corporations, civil society, social media, tech companies. These are all actors who themselves have been terminating their operations in Russia, selling their Russian investments, pulling out of Russia, and adding to the sanctions led by governments. So I think that's an interesting feature of this conflict, which we haven't seen much in previous conflicts. Is it being effective? Well, yes. The Russian economy is being affected. The stock market has and the ruble have devalued, interest rates have gone up, inflation is creeping up, travel has been much affected, businesses are being affected. They're predicting maybe a 10% contraction of the Russian economy. So it will go into recession, but it won't go into depression and it won't collapse. And Russia, of course, has also taken a whole lot of steps to protect itself from the effect of sanctions. So using alternative finance systems from Western ones, diversifying its export markets. I mean, lots of things Russia is doing to limit the damage of sanctions. What I'd also say about sanctions is that, I mean, the other side of this, of course, is that
Professor Saul, your voice is not clear. There is some problem with the voice. Sorry. We can't hear you. There is the creak sound and then it stopped. No, we can't hear you anything.
Give me 1 minute.
Sorry, friends, if there's some technical glitch from the speaker. We will wait for a few minutes. And thank you all for joining in this wonderful lecture. And if you have any questions, I would request you to either you can unmute your videos and ask your question by identifying yourself, or you may leave the question in the chat box so that I can put the question to the speaker. Thank you.
Professor, when is back, sir?
We will take maybe 2 more minutes.
Okay, can you hear me, Benaji?
Yes, yeah,
Yes.
Professor
Okay,
Saul,
good.
we can hear you. Thank you.
So let me conclude then just by saying on sanctions, in order to be effective, they have to be very damaging. But of course, the more damaging they are, the more damage you inflict on innocent Russian civilians who are not themselves responsible for their president's invasion of Ukraine. So there are human rights considerations in relation to sanctions as well. Also, when you have an authoritarian government like Putin's regime, it's not necessarily very responsive to the pain felt by ordinary civilians. I mean, Saddam Hussein's Iraq survived and prospered for a very long time, despite sanctions having very damaging effects on ordinary Iraqis and their ability to maintain their livelihoods and their health. A final point I'd just make, in addition to sanctions, of course, the West is providing a lot of weapons to Ukraine. I mean, just yesterday, the Ukraine president addressed the Australian Parliament, and Australia is sending more weapons in addition to the ones it's already sent. That's lawful under international law because it's an exercise of collective self-defense. Western countries and other countries do not want to put their own troops on the battlefield in Ukraine, but by providing weapons, that is at the request of the Ukraine government, and it's justified as collective self-defense indirectly of Ukraine. And it would be unlawful for any country to provide weapons to Russia to support its illegal invasion. One last point, I mentioned Russia's invasion is what we call aggression. Aggression is a grave, unlawful use of force against another country. So the Russian state bears international legal responsibility for it. But in addition, aggression is a crime under international law for which the leaders of a government who order aggression are also criminally responsible. Now, the problem here is that the International Criminal Court, although it does have jurisdiction to investigate war crimes and crimes against humanity in Ukraine, because Ukraine has given it jurisdiction, neither Ukraine nor Russia have agreed to the court's jurisdiction over the crime of aggression. So those committing war crimes on the battlefield, including their commanders and even including their political leaders who order them, could be held responsible for war crimes, but they cannot be prosecuted before the International Court for launching the aggressive war in the first place. Some have proposed setting up a special aggression tribunal where a bunch of countries could just create a court, which is really what happened at the end of the Second World War. The Nuremberg International Military Tribunal and the Tokyo or Far East International Military Tribunal were really just created by a bunch of countries creating a court and allowing it to prosecute aggression. Some have proposed that that should occur this time around to deal with Putin, the Minister of Defense, Putin's cabinet, those who are most responsible for taking the decision to aggressively invade Ukraine. There are other legal proceedings we can discuss in questions. The UN Human Rights Council has ordered an inquiry. Various European countries have launched war crimes investigations. And at the humanitarian level, of course, a lot's going on there as well. Over 10 million people displaced, 4 million of them refugees in other countries. The European Union providing refugee protection on a huge scale, and lots of questions about, why Europe didn't do the same thing for refugees from, for example, Syria or Yemen or Libya or other countries which weren't white refugees from Europe. I think you might ask the same questions about, the international community has mobilized to support Ukraine in a way that we have rarely seen in other situations where there has been really gross aggression or violations of other fundamental rules. Again, I think that reflects what the West is most interested in, and when it's most interested in exercising its power to uphold international law. Think of cases like Morocco's annexation of Western Sahara, the British government's ongoing colonization of the Chagos Islands, which the International Court of Justice said just recently is illegal, Israel's continuing illegal occupation of Palestinian territory. There are many examples of gross violations where the West does not impose sanctions on Britain or Israel or Morocco, or doesn't condemn them in the General Assembly, and doesn't provide weapons to Palestinians to defend themselves against Israel, and so forth. So there is a lot of selectivity and hypocrisy for political and security reasons, which also affect the way in which international law is enforced. If only those cases looked more like how enforcement is happening in Ukraine, we'd have a much more robust international legal order. Thank you, Professor Chaka, and I'm happy to take questions.
Thank you so much, Professor Saul. And it's a wonderful, you have covered extensively the entire subject of international law relating to the use of force, and also aspects relating to the self-determination and the sanctions. And it's a wonderful, and it's really a treat to listen to you again, being a student of international law. I'm sure most of our scholars and the students might have enjoyed our lecture. And now we have a time for some questions. That is, we have some questions in the chat box. Now, first, I would like to request the question posers. Would you like to ask the question by yourself, identifying yourself and unmuting your videos? You can do so. If not, I can read the questions to our speaker. Anyone? Aditya Roy, would you like to ask your question by yourself, or should I read? Okay, then let me read the question.
Good morning.
Good morning. Please go ahead, Aditya. Hello, Aditya. Are you there?
Good morning, Professor Saul. Yes, sir. Can you hear me?
Yes.
I can, yes.
Please go ahead.
Good morning, Professor Saul. My question is, you referred to the fact that the Russian support to the Donbass region is illegal, but had it been a country or an organization supporting Ukraine, that would have been legal, right? Had Ukraine asked for support in self-defense from NATO or some other country, that would have been legal. So my question is, do you think that Indian support to Bangladesh at the War of Independence to the regime of Sheikh Mujibur Rahman was legal or illegal? Because Pakistan was a state at that point of time.
Yeah. So when I mentioned self-defense in that example in 1971, I meant that India's claim was that it was defending itself from the effects or the impacts or threats emanating from East Pakistan. So it wasn't a case of collective self-defense because, of course, at that point, East Pakistan was not a state. It was an internal part of Pakistan as a whole, which, as you know, was then West and East Pakistan. I mean, there is some question about the facts in that case. So was this really an exercise of self-defense by India, or was it a kind of excessive or unjustified claim of self-defense? So certainly there was a lot of spillover of refugees from East Pakistan or Bangladesh into India. India was, of course, very concerned about the instability as a result of the conflict going on. Whether there were actual attacks on Indian territory or Indian forces inside India is an historical question, or was this, more a kind of imminent, anticipatory self-defense against an imminent threat? I mean, that's also part of the discussion. But yeah, it wasn't a case of collective self-defense. It does raise the question, and this was an issue during the decolonization period, whether self-determination movements themselves have a right not of self-defense against a colonial power, but a kind of analogous right to defend themselves against colonial military oppression. So only states have a right of self-defense. But the idea was that because self-determination movements under colonial rule are entitled to become states, they therefore should have an entitlement to some kind of analogous defensive military right, like like self-defense of states. And there was quite a bit of support during the decolonization period for not for self-determination movements to have a right to use force to liberate themselves from colonial rule. But if the colonial power denied self-determination forcibly by itself using violence to suppress the self-determination movement, then at that point, the self-determination movement, national liberation movements had a right to take up arms to defend themselves against the colonial violence. And the further argument then was, and other states should or do have a right to provide military support to the liberation movement to defend itself from colonial violence. Look, a lot of that was controversial. The West, of course, opposed it because the West, some of them were still colonial powers at that point. So no surprise they wouldn't agree to violence being used against themselves. But that's another facet of the Bangladesh example. Pakistan was already independent, so this isn't classic colonial self-determination. It's more like remedial self-determination of an identifiable subgroup within an existing independent state, i.e., Bengali-speaking, predominantly Bengali-speaking Pakistanis in modern-day Bangladesh, being culturally, linguistically, etc., separate for a long period from West Pakistan, and then being severely repressed with violence, denied inclusive participatory representation in the institutions of federal government, etc. And so in that light, is it also a case of remedial secession? And is there a right of foreign states to provide military support in situations like that, which would then provide a separate basis for India to argue its intervention was lawful? But again, that was all very uncertain at that time, and these days very much still is.
Yeah, thank you so much, Professor Saul. And I will read the next question, that is, sir, what are the key challenges to the operation of the rules on the use of force in contemporary international setting?
Key challenges, I think, well, there are some technical ones and there are some bigger picture ones. The big picture ones, of course, are those related to enforcement, right? These aren't new problems. International law, as we've said, is a decentralized international legal order. There's no global police force that can enforce the rules against violators. The best we have is the Security Council, and it can sometimes be paralyzed by the veto power. And we've given examples of how powerful states, West or non-West, can get away with aggression or illegally occupying or taking other countries' territories. Think of what my country did along with the UK and the US in 2003, illegally invading Iraq on the pretext of preventing weapons of mass destruction. We weren't attacked by Iraq. There was no Security Council authorization of our military action there, and we got away with it. Complete impunity, no prosecutions, no sanctions, no penalties. We didn't have to pay compensation. We installed a friendly government. It's a very imperfect system. On the other hand, to be more positive about it, the good news is that if you take a long historical view, since force was prohibited in international relations, 1928, 1945, interstate war, interstate invasions have actually become incredibly rare. The fact that there are so few, Iraq 2003, Ukraine now, some others over the years, is in some ways a success story, because before 1928, interstate invasion happened all the time, like literally every year for hundreds of years prior. Whereas you can count on a couple of fingers, hands, the number of interstate invasions in the last almost 80 years. That's a great success. Now, it's not just because of the UN Charter and the prohibition on the use of force. It's got to do with all kinds of other things, like the nuclear balance of terror and alliance systems and all of the realpolitik stuff as well. But the normative importance of a prohibition on the use of force has also very much shaped behaviour and raised the political and moral price of taking other countries' territories. Before 1928, you didn't even have to give a reason to use military force. I mean, it could be in self-defense, but it need not be. I mean, you could go on religious crusades, you could take territory and plunder it for colonial reasons, you could punish another country because you didn't like something they did to you, like breach a treaty obligation or just did something unfriendly. You could invade on humanitarian pretexts, for economic reasons. I mean, there was no end to the reasons states used violence as a tool of statecraft, and as violence. Violence was a tool of international relations. So I think that the good news is that although the situation in Russia, Ukraine looks bleak from our current standpoint, the bigger picture is a much more successful one. When I mentioned, technical challenges to the rules, there are things like how do these rules, which go back over almost a century now, how do these rules cope with things like modern technology, like cyber attacks, operations, etc. The law on the use of force prohibits the use of military force, which presumes a kind of use of kinetic destructive violence, killing people, burning buildings, destroying them to rubble, etc. How does that translate to what we know of the destructive capacity of cyber operations? I mean, cyber operations can absolutely have those effects as well if you can harm people or destroy property through interference in electronic systems. But they can also do a great deal of damage by simply destroying intangible data, wiping bank records or stock market records or civilian health records or social security information. All of those things can do untold damage to countries, but aren't traditional kinetic destructive effects. So there is a current debate about how the law on the use of force deals with and classifies cyber operations.
Yeah, thank you so much. And the last question, maybe this one: can a military intervention by a country against China be justified to free the Tibetan state from the Chinese occupation? And also taking into account the assumption of a genocide against the Tibetans.
Yeah, so we discussed previously how there really is no accepted legal right to use force even to prevent genocide. It's part of the larger debate about humanitarian intervention, flowing on from ethnic cleansing, which is a step prior perhaps to genocide in Kosovo in 1999. Certainly, NATO did it, so they thought, and the British government argued humanitarian intervention is lawful. Most countries didn't agree. There was then a process within the United Nations, which resulted in what we call the responsibility to protect doctrine, which essentially says all countries have a responsibility to protect their own people. And if they fail to do that, other countries will step in and protect people from serious international crimes and so on. But the limitation of the R2P, or responsibility to protect doctrine, is that it still ultimately only permits military intervention on humanitarian grounds if the Security Council authorizes it. So it still has to be a decision taken by the Council, and therefore one subject to the veto of the great powers. It doesn't authorize unilateral humanitarian intervention like we saw in Kosovo in 1999. In terms of the other part of your question, Tibet as occupied territory. Yeah, so this is a difficult one because of the way that the international community has approached the Tibet question. On one view, Tibet was an independent political entity prior to the Chinese invasion and occupation and annexation. So incorporation, like Russia did to Crimea, China has just annexed Tibet as part of China proper. They just regard it as a sovereign part of Chinese territory. So China says, like Russia, that's because Tibet was always part of China. Tibet says that's just not true. There were links, various links between China and Tibet, but it was never a part of China proper, and therefore should not be part of the Chinese state. Now, the West reacted to that, and the international community reacted to that by essentially accepting the Chinese version of events. So even those states which are concerned about human rights or genocide in Tibet, none of them recognize a Tibetan right to be an independent country. None of them accept that Tibet has a right to secede from China. That tells you one of two things. It tells you either the world just agrees that China's claim was right, Tibet is part of China, and China has a right to it, or these are politically tainted decisions by the international community to appease China, go along with the Chinese claim, to not stand up for Tibet in the way that the world doesn't stand up for Chagos Islands or the Falkland Islands or other territories the West has kept controversially according to the self-determination principle under international law. So it's hard when countries are nuclear armed powers. There's a limit to what you can do. There's a limit to what you'll ever be able to do to the US or Russia or the UK or France or India for that matter, which has nuclear weapons, Pakistan. That is a hard limit on what other states are sometimes willing to do to enforce international law because of the power that those weapons give those states. An outsized power nuclear weapons give those states to avoid the consequences of breaking international law.
Okay, thank you very much. And I have one more question just come up. That is a last one, perhaps. Russia keep on saying that we have a special armed action against Ukraine, but does it qualify as an international armed conflict?
Yeah, good question. So in the old days, before the United Nations Charter in 1945, it mattered what the states involved called what was happening on the ground. So for there to be a war, legally speaking, prior to 1945, the states involved had to declare subjectively that there existed a state of war, and then various legal consequences flowed from that. The modern approach post-1945 and in the law of war post-1949 and the Geneva Conventions is that it is not necessary for the country itself to declare there's a war, to characterize it as a war, to accept that there is a war. So the fact that Russia calls it a special military operation and avoids calling it a war or an armed conflict is irrelevant. What matters is whether the objective international legal tests are met for, number one, the use of a prohibited use of force under Article 2.4 of the Charter, and therefore whether there's also aggression and armed attack for self-defense. And then when we're talking about the conduct of the war once it gets underway, what we call international humanitarian law. Of course, there is what we call international armed conflict, because under the Geneva Conventions, an international armed conflict is simply a use of military force between two states, and that's obviously what we have. That then triggers all the rules of international humanitarian law, many of which we're seeing violated on the ground. War crimes include things like deliberate attacks on civilians or civilian objects, indiscriminate attacks on civilians, disproportionate attacks, where you target a military objective, but in doing so cause excessive civilian casualties, inappropriate use of weapons like cluster munitions or vacuum bombs in urban areas where you can't avoid hitting civilians, attacks on specially protected objects like hospitals, nuclear power plants, and so on, as well as sexual violence, murder, abductions, forced displacement from occupied territory. I mean, there's a long list of possible violations happening under the law of armed conflict under the Geneva Conventions.
Thank you so much, Professor Saul. And before winding up, can I ask all the participants to just unmute their videos so that we can have a quick group photograph virtually? Thank you very much. Quickly, so that we'll take a group picture, and it will be a fantastic one. It's nice to treasure, because we have a very illustrious speaker from across the shores. Please, kindly, I would request all of you quickly, whatever the phase, whatever the pose you are, don't worry, kindly. Shivani, Aditya, please unmute your, thank you. Okay, just all of you cheer up and put nice faces and smile on your face so that we can have a good picture. Thank you so much. Thank you very much. And now I profusely thank Professor Saul for taking his precious time. He's working these days on his book, and in spite of his schedule, he gladly agreed to speak with our students and participants at VAT AP School of Law. Sir, on behalf of VAT AP School of Law, VAT AP University, Andhra Pradesh, we thank you wholeheartedly for taking your precious time and speaking with our students. And we are really indebted to you. And in fact, it is one of the wonderful sessions which you gave, giving that a whole lot of ideas of international law. And I'm sure our students, participants, and they have benefited immensely. And we also look forward to you to host you physically when you are visiting, when you have some free time to come to India. We will definitely host you to come to our campus. And we have an opportunity to meet physically in the days to come. With this, I once again thank you and thank all the participants for patiently listening this wonderful lecture given by Professor Saul. Thank you so much, sir.
Thank you.
Thank you very much.
Goodbye, everyone.
Goodbye. Thank you, sir. With this, we will end the session, and we will come forward and with one more session in the future. Thank you very much, sir. Thank you, all of you. Bye-bye. Thank you, Professor Saul.
Thank you, sir. Thank you.
Thank you. Thank you.